I am the President and General Counsel of Stand with Asian Americans, the nation's first civil rights organization focused on anti-Asian workplace discrimination. Chair Lucas, in April, when asked why this commission collects information about the people it protects, you answered, "There's no other way to protect victims of harassment or discrimination unless you collect information on them." That is our position in a sentence. We oppose the proposed rule rescinding EEO1 and related reporting requirements, and I would like to raise 3 points for the Commission's consideration today. First, what this data means for Asian American workers. The EEO1 report is the only federal instrument that exposes what we call the bamboo ceiling. Asian Americans are often well represented in the professionals and technicians job categories, yet conspicuously absent from officials and managers, according to the Commission's own report and other independent analyses. Simply put, Asian American workers are the least likely group to be promoted into management. A total headcount does not show that gap. It appears only when the counts are broken out by job category, which no other federal report does. So while the Commission concludes this data is not narrowly tailored, for this community, it is the most precisely tailored instrument the Commission has. Further, the model minority myth that Asian Americans face no employment barriers persists because it is rarely tested against evidence. Data collection does not create that stereotype. It is the only thing capable of rebutting it, and counting does not create that stereotype. It disproves it. We commend the Commissioner's 2024 edition of the Middle Eastern and North African category, and we should do more. The current Asian category collapses more than 20 national origin groups with different labor market outcomes. Hmong, Cambodian, Bangladeshi, and Burmese workers have employment and wage profiles that differ significantly from the aggregate. The reform we need is better, more disaggregated data, not none. Second, the proposed rule offers targeted requests during an investigation as a substitute. However, a targeted request presupposes a target. Someone has to complain first. Asian workers file EEOC charges at rates well below their share of the workforce. That is not because the discrimination is absent. Roughly 1 in 5 Asian adults report experiencing racial discrimination at workplaces, yet they file charges at very low rates. There are many reasons for such gap, including fear of retaliation, concern for reputation and job mobility, cultural reticence, immigration status, and language barriers. Nationally, the overwhelming majority of workers who experience discrimination never file a formal charge. As an organization that provides legal support for Asian Americans facing workplace discrimination, we see this every day. A system that relies only on individual charges makes underreporting communities statistically invisible. Only EEO1 data gathered before any dispute gives the Commission, employers, and the workers a baseline against which conduct can be recognized as discriminatory that no single complainant can show. Third, the proposed rule contains legal and procedural inconsistencies. Title VII protects individuals regardless of the group they belong to. That principle applies in every direction. Every charging party needs comparative evidence, including members of the majority group, following the Supreme Court's decision in Ames. EEO1 data will provide the charging party with evidence to substantiate a claim rather than inference based on the colleague's appearance, and will provide the Commission and employers readily available and reliable information with which to investigate. In addition to this commission treating these reports as essential to enforcement for the past 60 years, the proposed rescission conflicts with existing legal mandates and procedures, such as the congressional mandate, the Uniform Guidelines on Employee Selection Procedures, and OIR's recent approval of this collection through 2029. The 30-day comment period is also inconsistent with the 60 days contemplated in the Commission's regulatory agenda. In closing, we respectfully ask that the Commission first withdraw the proposed rule. Second, extend the comment period to 60 days. Third, disaggregate the data for Asian and other overly broad categories. Fourth, publish guidance affirming that voluntary employer self-audits remain lawful. And fifth, preserve the Pregnant Workers Fairness Act related revisions proposed in 2024. The EEO1 report is not a burden. It is a promise that this nation's civil rights laws will be enforced with evidence, not guesswork. We ask you to keep that promise. Thank you.